Let me just go ahead and get it started then. Okay, so this is a workshop on family-based immigration, and it's actually a continuation of a workshop that we started in the fall semester. So in the fall semester, we had a family-based immigration workshop, and it was kind of just an introductory workshop. There was lots of attendees and lots of questions. So I thought it would be helpful to have like a part 2 to the workshop. So we'll be going over the basic things that we went over in the first workshop for those of you that missed it. But then I've added a couple more things, including some hypos, so that it's easier to understand some of the complex topics. And I will just give a little caveat here. I think that family-based immigration is probably the most complicated topic in immigration law. So we're going to be giving like a very broad overview of what it's like and answering some of the most common questions, but it's really complex, and you should be taking advantage of the free legal services available through ELAC to get a personal consultation if you have, if you think you might have a family-based case. So with that, I'll dive in here. So the information that I'm going to be giving during the presentation, again, it's just general information and some hypotheticals, but it's not legal advice, and your situation may be a little different. You'll note here that just with a slight difference in the different hypotheticals, the outcome of the case could change. So if you have any questions about your personal case, I encourage you to schedule an appointment. And I put our Simply Book Me link on there, where you can find available appointments at ELAC, or you can also contact the DRC if you need help scheduling the appointment. There will be a Q&A at the end to go over questions that come up in the presentation, but try not to ask personal questions during the Q&A. So if you have a personal case that you want to talk about, just schedule an appointment with us. We're very available, and that way we'll avoid having to answer personal questions in a public space, especially because it's getting recorded and will be put on YouTube. And then I did just want to mention one other thing, that there'll be a new CARECEN staff attorney that'll be assisting ELAC students, staff, and faculty. So stay tuned. She'll be joining this. Actually, tomorrow's her first day. So some of you that are booking appointments now may be getting your appointments booked with her. So the agenda for the day, we're going to talk about what is a family-based petition, which family members can petition who, what are the requirements, what does the process look like, how can it lead to citizenship, what about public charge? That was a big topic in the news yesterday, so we'll be talking about that towards the end, and then going over how to book an appointment at the end. And I'll try to be respectful of time, so I'll try to finish the presentation portion by 12:45, 12:50, so that we have enough time for questions at the end. With that, we'll dive in. So what is a family-based petition? So family-based petitions allow certain green card holders and U.S. citizens to petition for other family members to be either allowed to come into the U.S. Or to apply for a green card in the U.S. And it's a pretty complicated area of law, as I mentioned at the beginning. So to make it a little bit simpler, I'm going to be talking about it as two different processes that the person would go through. The first step in a family-based case is a family petition. And the family petition part's really easy, relatively easy. It's basically the relative that's a citizen or a green card holder files a formal petition with immigration saying, I want this family member to be able to join me in the U.S. So the restrictions aren't, there's not a lot of restrictions. The restrictions are mainly who can petition who, and not necessarily looking at some of the more complicated, what are called grounds of inadmissibility that we're going to be talking about a little bit later. But the first part's relatively easy. The more complicated part is being able to apply for residency based on the family petition. And that's where a lot of people end up finding that they're either ineligible or they have to leave the US or they need some kind of a waiver. So people sometimes get confused because they hear, oh, well, an immigration officer told me that I could file a petition, or a notario told me that I could file a petition. Whereas that's usually the case. Filing the petition is the easy part, but actually getting your residency through that petition, that's the complicated part. And that's going to be the majority of what we're talking about today. So who can file a petition? I have a little table here. Citizens and green card holders are the only two categories that can file family-based petitions. And in the citizen category, there's more relative types that a citizen can petition. So a citizen can petition parents, a spouse, siblings, children under 21 and over 21, and married children. And just as a note, to be able to petition for parents and siblings, a U.S. citizen needs to be at least 21 years old. And then green card holders are limited to petitions for their spouse, children under 21, children over 21, but if the child is over 21, they can't be married. So the kind of categories that are excluded if the person is a green card holder are parents, siblings, and married children. And I will note here that the categories that are bold and underlined, those are considered immediate relative categories, and there's special laws that apply to those types of petitions. And oftentimes it's easier for the person to be able to immigrate quickly if they find themselves in one of those categories. So how long will the process take? A very complicated question. Processing times vary widely. It depends on the petitioner's status. So are they a green card holder? Are they a citizen? And the relationship of the petitioner with the family member that they're trying to bring. And also sometimes what country the applicant's from. So I have here this pretty complicated chart with dates, and I have just copied and pasted this from the Department of State Visa Bulletin. And every month, the Department of State publishes what date they're processing visas for. So I mentioned before that the first part, the family petition, is the easy part. And it's basically formally saying that the U.S. citizen or green card holder wants a family member to join them in the U.S. And filing that petition kind of like gives the person their spot in line. And for certain categories, the wait to actually get to the front of that line is really long. So for example here, you can see that some categories are taking about 7-8 years, 2014, 2015. So they're, a long time. And then some of them where there's applicants, where there's a large number of applicants, it's taking a really long time. For example, if you look at the fourth column there, Mexico is processing some cases as old as 1996. So we're looking at least 25 years there of waiting for the date to become current. So filing the petition kind of just reserves your spot in line. And then when you get to the front of the line, so when your date becomes current, then you would apply for your residency based on that petition with a date being current. So already you can see it's getting a little bit complicated because of the dates and all of the different categories that are involved. So what does the process actually look like? I've separated it into like 4 parts here, but actually each of these parts have like 15 subparts. So the first part is the petition, where they're just saying, I want my family member to join me. Here's my money and the application and my spot in line. Part 2 is applying for residency through the petition. And applying for residency through the petition could potentially be done within the U.S., or they may have to go abroad for an interview. And in a couple of slides, we'll be talking about how to decide if a person might be eligible to have their interview here. And then the third part is the actual interview. So meeting with either an officer abroad or an officer in the US to go over the application and hopefully get approved and get the green card. And then later, at least 3 to 5 years later, the person would be eligible for citizenship. So what are the most common ways for somebody to be able to have their interview in the US? Where will the interview be? So whenever we see somebody who's interested in a family-based petition, that's kind of the first question we're asking. Is there any way that we can help this person to be able to get their interview in the US without having to leave the country? And there's 2 main avenues to do that. One is if they're an immediate relative and have a lawful entry. And the official legal term for that is inspected and admitted and or paroled. But it's kind of easier to just think of it as a lawful entry. And just as a reminder, the immediate relative is a spouse, a minor child, or a parent of a US citizen. So those 2 things have to be met for the person to be able to apply for their residency in the US. So sometimes we'll see people who maybe entered on a tourist visa and they're married to somebody with a green card, and they'll be like, oh, well, I have the lawful entry card. I know that I need that to be able to have my interview here. Can I apply and get my green card without having to leave the US? And our answer is generally no, because they only meet 2 of those, or one of those 2 things. They have the lawful entry, they entered on a tourist visa, but they're not in an immediate relative category yet because their spouse would be a green card holder. So both things need to be met for the first kind of exception to get the interview processed in the US. The next one, which is a little bit more complicated, and every year is becoming like increasingly harder to find, is if the person was grandfathered under Section 245I of the Immigration and Nationality Act. And this is an old section of the Immigration Code that allowed somebody to pay a fine of $1,000 to not have to leave the US. So this was super helpful to a lot of people who were subject to going abroad for their interview. But unfortunately, the law sunset, so it ended in 2001. But anybody who had a petition filed for them on or before the date that it ended, April 30th, 2001, could still pay a fine of $1,000 and not have to leave the US. So to have a petition filed on or before that date, it can either be a family-based petition or it could be an employment petition. So in 2001, we saw a lot of people having petitions filed for them in categories that take a really long time. So that sibling category that I mentioned that was processing in 1996 or 1998, that's still not current. Those people are all grandfathered into 245I. And I'll note here that even if they end up using the petition and applying through somebody else in a faster category, they can still take advantage of paying the $1,000 to not have to leave the US. So within the Community College Project, where we see this area coming in the most is for people who were minor children at the time a petition was filed for their parents. So maybe in 2000 or in 2001, your uncle or some other family member petitioned for your parents. You would have automatically been included in that petition. That means that you're still protected by this law 20 years later. We also see it in a lot of employment petitions. So if your parent worked for an employer who petitioned them in the 90s or 2000, 2001, then you would have been automatically included and you can still take advantage of that 245I. So you'll notice you have a consultation with us, so sometimes we're asking questions that may seem all over the place for a family-based consultation. You may be like, well, why do they need to know if my parent was working in an industry that petitioned them before? And it's because of this, we're trying to figure out any way that we can get you to be able to have your interview in the US without having to leave. So moving along here, I want to talk about other scenarios in family-based immigration that may help somebody. So how could advanced parole help somebody to not have to leave the U.S. for an interview? So advanced parole is available in a lot of different scenarios, but the two most common are if somebody has DACA or TPS, they can ask for permission to leave the U.S. and re-enter in the same status. So maybe they have to travel abroad for something. They can ask for this advanced parole document. It takes a little while for it to get processed, and they can travel abroad and then come back in the same status that they left. And if somebody has DACA, traveling on advanced parole can satisfy the inspected and admitted or paroled requirement. So the legal entry to be able to have the interview in the U.S. And I just wanted to note again, it's two things that have to be met. It has to be an immediate relative category. So a spouse, a minor child, or a parent of a U.S. citizen, and have that legal entry. And for DACA advanced parole, the applicant needs to link their travel to one of three reasons: educational, professional, or humanitarian. And humanitarian is kind of a catch-all. If you have like a sick relative abroad or other humanitarian reasons, you may be able to get advanced parole that way. So a lot of people that have DACA that didn't have that legal entry when they first entered the U.S., they travel on advanced parole to be able to get that legal entry if they do have a relative who's in one of those who could petition them, or in the event that in the future they might have a relative in that situation who could petition them. And the cost is $575. So it is a steep application fee, and it's there's no fee waiver available for it. And I just wanted to note that you do have DACA or TPS and are interested in traveling on advanced parole, CARECEN's Community College Project is happy to help you with the application. We don't have the filing fee assistance for the immigration costs, but we can do all the legal work for free for you and give you advice on if advanced parole may be the right choice for you. The other situation that kind of changes in family-based immigration is if a person has TPS. So in 2017, there was a very important case in the Ninth Circuit in which California is located, Ramirez v. Brown, that held that TPS counts as an admission. So if somebody has TPS, even if they didn't have that traditional lawful entry to the U.S., like coming on a tourist visa or advanced parole, the mere fact of getting TPS counts to meet that requirement. So if somebody has TPS and they have an immediate relative, spouse, minor child, or parent of a U.S. citizen, then they could potentially apply for their residency in the U.S. without having to leave. And the other common scenario that we see come up at the community college level is people that have a family member in the military. That sometimes helps. If the person is a spouse, widow, parent, or child of somebody who's in the U.S. Armed Forces, in the Select Reserve of the Ready Reserve, or someone who was honorably discharged, they can ask for parole in place to meet the legal entry requirements. And this one actually doesn't involve traveling abroad at all. It's basically the government agreeing that the person has like a theoretical legal entry just by the nature of having a family member in the military. So that's also an important kind of exception to get within the category to be able to have the interview in the U.S. So I have a couple of hypos. I'm going to check the time here. Okay, we're doing good. I have a couple of hypos that I wanted to talk through to kind of flesh out some of these more complicated scenarios. So the first one, Adam is married to a U.S. citizen and came to the U.S. when he was 4 years old. He got DACA in 2014 when he was 17 years old. So Adam comes to my office and he says, I'm in this situation. Can I get my green card? So the kind of questions that I would ask Adam to figure out if he might be eligible to get a green card. I want to know, how did Adam enter the U.S.? So I'm trying to see, I see he's in that immediate relative category because he has a U.S. citizen spouse, but I want to see, was he also inspected and admitted at some point? So let's say that Adam tells me that he came on a tourist visa. So then I think, okay, this is easy. At least I'm talking about a situation where Adam can have his interview in the U.S. But let's say that Adam didn't come on a tourist visa. Let's say that he remembers that he came, but he didn't have any paperwork with him. He doesn't have a lot of memory of exactly what happened because he was 4. He just knows that he didn't have a visa. So then I would start asking other questions. I know that he has DACA, so I'd ask him if he ever left the U.S. So let's say that Adam says, oh yeah, I traveled abroad for a study abroad program in 2016 on advanced parole. And then I think, okay, again, we're in the same situation here. We have the immediate relative category, and he's able to satisfy the legal entry by having traveled with advanced parole. But let's say that Adam says, no, I've never left the U.S. I came when I was 4 and I've never wanted to travel. So now we're looking at a very different scenario. And I don't see any way that Adam could have his interview in the U.S. unless he had a special 245I, but let's assume that he didn't at this point. So I would probably start talking to him about if he wanted to travel on advanced parole now. That would be one option. So there's a lot of other questions that I would ask for Adam to determine Adam's eligibility. But I've used this as an example to just kind of hit the basics of the kind of questions that we would ask and where a consultation might be. So this next one here, Anna's uncle petitioned for her mother in 1999 when Anna was a minor. She never got a green card though, because sibling petitions can take a long time. She's now married to someone with a green card. So this first thing I'm thinking here is, number one, she's not in an immediate relative category because she's married to someone with a green card, not a U.S. citizen. But I know that there was a petition filed in 1999 for a parent. So now I'm thinking, okay, so she's probably eligible for that special 245I law, where she could maybe pay a $1,000 fine and be able to have her interview in the U.S. because that other exception there didn't require an immediate relative category. So again, there's probably 30 more questions I would ask after that, but that's kind of the general, at least I figured out probably where she would have her interview. So I get this question all the time, what's the 10-year bar? So the 10-year bar was introduced into immigration law in 1996, and it states a couple different things. It states if anybody has more than 180 days of unlawful presence, then they could be subject to an unlawful presence bar. And it basically means that if somebody ever leaves the U.S. after having unlawful presence in the U.S., that they're barred from re-entry into the U.S. And 180 days of unlawful presence would bar somebody for 3 years. But 1 year of unlawful presence would bar somebody for 10 years, which is a more common scenario. And unlawful presence is a legal term, and it basically means that the person's in the U.S. without any immigration status. So if somebody has TPS, then they're not accumulating unlawful presence days. Somebody has DACA, they're not accumulating unlawful presence days. Generally speaking, if somebody has a pending immigration application, they're not getting those unlawful presence days. But the more common scenario that we see is somebody comes to the U.S., maybe let's say they came in 2000, and now they're at the point where they are thinking about applying for a family-based petition because they have a relative but maybe they've been in the US this whole time without any immigration status. So under this 10-year bar law, if somebody leaves the US, then they would have a bar against their return to the US for 10 years. So that addition into immigration law in 1996 really hurt a lot of otherwise eligible family members from being able to immigrate to the US. So it had a very negative impact on family-based immigration. There is a waiver that people can apply for so that they don't have to wait the 10 years outside of the US. But in order for the 10-year bar to go into effect, somebody actually has to leave the US. So how this all plays out in immigration law is if somebody is applying for a family-based immigration case and they're not able to have their interview in the US, they're subject to go abroad for their interview. For a lot of people that have more than a year of unlawful presence, the moment that they get on a plane or leave the US for their interview abroad, that moment, the 10-year bar kicks in. And we've seen a lot of people that were victims of notario fraud, and they were never told before they left that the moment they left, they were going to have this bar. They thought they were just going abroad for their interview. And then at their interview, they're told that they have a 10-year bar. So up until, actually, I don't remember the exact year, sometime around 2013, somebody had to actually leave the US and apply for a waiver to come back in. But in around 13, again, I don't remember the exact date, under the Obama administration, they created what's called the provisional waiver. And under this kind of special law, somebody can provisionally apply for a waiver before they even leave the US, so before that 10-year bar is even in effect, so that they travel abroad. And the moment they travel abroad and have their interview, they see that the officer will see that there's a 10-year bar, but that they already have a waiver that was provisionally approved before they left the US. So in that scenario, it reduces the amount of time spent outside the US, which could be years while the waiver was adjudicated, to weeks, because the waiver was already processed before the person left the US. To be eligible for a provisional waiver, the applicant needs to show that they have a family member who would suffer from extreme hardship if they weren't in the US. However, the waiver is limited to how a spouse would suffer or a parent would suffer. So they don't take into account how someone's children would suffer if they weren't in the US with them. It doesn't change how long the wait is for priority dates. So if somebody's in one of those categories that's 20 years long, it doesn't change that. And it's also only available if the unlawful presence ground is the only ground being waived. And that's a very technical thing that we would go over more in depth with people, but I just wanted to mention it here. I do a quick time check before I jump into the next one. Okay, we're doing good. Okay, so a hypo. Alejandro came to the US without a visa when he was 17 years old in 2004. He has been living in the US since then and has not left. He has a US citizen spouse who can petition him, but he heard that he might have to leave the US and is afraid to start the process. So in this hypo, without asking more questions to see if maybe he had that special 245I eligibility, but just with the facts here, I'm thinking, oh, he might be eligible for a provisional waiver. We know that he's been here since 2004 and he hasn't left. And assuming that he hasn't had any immigration status during that time, we can assume that he would have that more than a year of unlawful presence. And when he left for his interview abroad, he'd have that 10-year bar. At this point, the types of questions that I would be asking him are how his U.S. citizen spouse might suffer if they were separated. So maybe we can show that his spouse would suffer emotionally if they were separated, or maybe they're financially dependent upon each other. There's all these different ways to show that a relative would suffer if separated from another relative. And CARECEN is helping with these types of waivers still. So if you think you might be in that scenario, please make an appointment with us. And will I pass my interview? It's the question everybody asks. So I kind of just went over like the basic roadmap of what the process looks like here. But there's a bunch of other questions to make sure that the person will actually be able to get their green card through a family member. So just having the family petition isn't enough. An applicant also needs to be what's called admissible to the United States. And there's a bunch of different things that might make somebody inadmissible. For example, certain criminal records might make somebody ineligible. If somebody's ever left the U.S., especially multiple trips outside of the U.S., complicates things. The unlawful presence issue makes somebody inadmissible, and again, that's why there's that waiver. If the person's ever committed fraud or helped somebody to enter the U.S., been in immigration proceedings before, all of those things might affect the case, and also likely to become a public charge, which I'm going to talk about in just a second, can affect the case. So this is one of the many reasons why it's important to take advantage of free services to get an analysis of your case, so that you're not just trying to navigate it without understanding all the different how all the different pieces kind of connect. With that, I'll jump ahead to public charge. I did this yesterday, so I wrote today, but it was actually yesterday. There's a big change in public charge. So the Biden administration dropped its defense of the Trump public charge rule. And as a result, the U.S. Supreme Court and the Seventh Circuit dismissed their pending cases, which brings an end to the new public charge rule. So finally, the public charge roller coaster that we've been on for the last almost 3 years now has come to an end. I will say that public charge is still a part of immigration law. It has been for a really long time. What the Trump administration attempted to do was change the definition of public charge to make it more difficult for immigrants to not be considered a public charge. So what the Supreme Court dismissing the case actually means is that we're going back to an old definition of public charge that's easier. And just as a side note, not only did the public charge rule, the new public charge rule get dismissed in the US, but also it's no longer being applied at consulates and embassies abroad for those that are applying for their interview abroad. With that, I think I'm doing good on time. We have enough time for questions, but before we dive into the questions, I just wanted to remind people that please make an appointment. We have appointments available for students, staff, and faculty. And if you're a community member or a family member that's joining us, please hop on CARECEN's website. We offer free services through libraries, family source centers, through our main office and satellite offices. And for right now, everything's being done virtually. So services are more accessible than ever. We can do them over the phone if you don't have access to like a smartphone, or we can do them over video. And with that, I will open it up to questions.
Hello, everyone. So I have clicked the option so that you can unmute yourself if you would like to ask a question. So you can unmute yourself and ask a question now.
Marcela, in case of we have some questions already there.
We do. Yes,
that maybe we can go over. For example, one of the is Isabella Garrido said, what about an aunt and uncle? I'm pretty sure this is about when you were talking about the family, petitions. Isabella is asking about an aunt and uncle. If they can, Isabella, you there so you can elaborate a little bit better?
I don't think the student is here anymore.
Okay. Okay. There's another question that is said from Mo. Is how about parents of a minor child? Mo, are you still here so you can elaborate your question better? And there's a more explanation.
Oh no, I just hear me?
Yes.
Oh, okay. Yeah, that's just the question. Yeah. So how about if the minor child has the citizenship, but the parents don't have? So yeah, can we?
You muted yourself, Mo.
Julie, you're muted.
Of course, I'm new. Thank you. For a child to petition their parents, the child has to be 21 years old. So that's the negative part of the immigration law. They have to wait till they're 21.
Okay, thank you.
I have a question that that they brought in while they registered. There's a question saying, are there any resources for youth coming out of detention centers? I'm assuming it's immigration. Victoria G, would you like to elaborate? I think she's here. She's not there. Are there any resources, Julie, that you know if they're maybe undocumented and incarcerated minors?
Yeah, so our specific project, the community college project, it is limited to students, staff, and faculty of community colleges. But CARECEN as a whole has much broader like case acceptance criteria. So if somebody is in that situation, we could give them a consultation to see, if they're eligible for anything and to see if we'd be able to take the case. And again, our website there kind of lays out all the different ways that people can access the services virtually.
Thank you. There's another question. Oh, sorry.
Kelly has the hand up. Kelly, can you open your microphone?
For me? Are you able to hear me?
No, Kelly Dong has her hand up.
Oh,
Kelly, can
Hi, good afternoon. Can you hear me?
Yes.
yes, we can hear you.
Okay. May I ask one question? Because several years ago, I applied for the asylum, but they denied, and go to the immigration court. The judge gave me a PD. The judge said the PD is not a green card, but just can stay in the U.S. legally. So right now, I apply for the green card directly.
So that's kind of a bigger question. We'd probably have to go over somebody's complete history to see what you might be eligible for. There's no way to go directly from PD status to a green card, but there's a lot of things that can happen in between. So if you are a student, staff, or faculty, just book an appointment with us and we'll go through your entire record and see where we might be able to help you there.
Well, how can community people like that are not student, staff, or faculty get in touch with CARECEN?
Yeah, I put our website on the slide here. It's www.carecen-la.org. And that lays out all the different ways that you can access services through our organization.
Yes, I called the number there, but no one answered.
I think that it's through a voicemail now. Our receptionist is working from home. So if you leave your number, then she returns your phone call.
Okay.
这有没有 email？
Do you have email?
They don't have an email system set up. It's all through the phone right now.
Okay.
问他有没有？May I ask? Do you do the SIJS for the the children apply for the green card?
So we do special immigrant juvenile status, SIJS, and for student, staff, and faculty, we do that for free. Otherwise, we do it through our CARECEN central office.
Okay, so
Okay, but that is my friend, and if he contact with you, pay you, can you do that?
So most of CARECEN services are free of charge, but again, we have to actually give somebody a consultation to understand their complete case before they will be able to take on the case or not. But most of our services are just free.
So Kelly, make sure that you can contact them and under www.carecen.la, so that way you can communicate with them. That way they can make sure that they can answer all your questions in that regards, okay? So I'm moving on because we had only a couple more minutes. So I had a question here. Hello, I'm trying to finish a school here in Los Angeles. My wife lives in Nevada. Does we had to live together to petition?
Can you give the lawyer's email?
I actually can't give out the emails. All of our appointments are booked through the phone. Sorry, it's just the nature where we're at remotely right now in technology. For the person with the question about living a spouse that lives in another state, it's not a requirement that you live together to file the petition. It's a little bit more complicated. You have to show that you entered into the marriage in good faith, but it's not a requirement that you live together.
Okay, thank you. I had another question from Emily. In order for a child over 25 to petition for a parent, the parents must have come legally?
Again, that's a more complicated question. So we know that we're talking about an immediate relative petition there. So for somebody to be able to have their interview here, we want them to be able to have that inspection and admitted requirement. But if the person had TPS, that would count. If they travel on advanced parole, that would count. Military involvement, that would count. And again, if the person might be protected through 245I, that could also count. So there's like a lot of different factors that work. We're happy to just give a consultation to see if the person might fit into any of those categories. But those are the main ones.
Okay, thank you.
We have Linda with her
with the
hand.
hand. Linda Chacon, but previously it was another person. I don't know if she's gone, but right now the one with the hand up is Linda Chacon. Linda, can you elaborate your question? Linda Chacon.
Hello, everybody. Can you hear me?
Yes.
Okay, I have one question. So I have a family member. The person came here 2007 and hasn't left the US. And how can my family member be eligible? How to find out if the family member can receive a green card?
So the best case scenario that we could do is speak directly with the family member. And to give people an idea how it works, when we meet with somebody, we go over for about 20 to 30 minutes, just their complete immigration history to figure out what we might be able to do for the person. So just knowing that somebody came in 2007 isn't really enough to be able to actually give you really any direction at all. We'd have to speak to the person directly or ask like 20 follow-up questions. So I will just remind people that If you have general questions, this is a good space for general questions if you didn't understand a part of the presentation. But if you have specific questions on your case, chances are I'm probably not going to be able to answer them in this setting, but we're happy to do it in a one-on-one setting where we can take 30 minutes and get the complete history.
Okay, do you charge for that?
All of our services are free.
Okay, thank you.
Remember, participants, if you are ELAC student, all the services are free, but you are part of the community, they also have some services that can be helping. Elizabeth Ortiz, I know I saw your hand. Can you elaborate your question? If that is a general question, like she mentioned it.
Yes, thank you. My question is, if I had petitioned for my spouse back in 2005, but I didn't continue the process, do I have to restart all over, or is he already in the system?
I know that you're going to hate this answer, but it depends on what happens with the petition. So sometimes immigration can close or revoke or withdraw a petition if it's been a long time. So the best thing you could do, again, meet with us personally, but when you meet with us personally, if you could have your receipts from immigration handy, and we can always check things online to see statuses of cases to be able to give you more direct information.
Okay, I would try to look for that receipt, and I did make an appointment, so thank you.
Thank you.
Julie, how are we doing on time? Are you still good, or Thomas? I know it's a little over.
I can do a few more questions.
Okay.
Thank you, Julie.
Thank you. Marubeni, do you have a question?
Yes, mine is also specific, so I'm going to make an appointment. But yes, in the simplest terms, I petitioned my husband in February. We've been married for 2 years. I'm a citizen, and he was born in Mexico. So he has 2 entries without inspection. So I'm assuming we're going to do a waiver. My question is, do you think that I should like try to take care of it right now, like make an appointment and start working on that? Or can I do it later, or I should start looking for help like through your services? Or
I would start looking for help now. Waivers are super complicated and they take a long time to get all the documents together. So if I were you, I would start now.
Okay, perfect. Thank you so much.
And we have one question there in writing from Katia. We don't have any more hands, but I had a question, Katia. If my parents who is undocumented is getting married to U.S. citizen, are they able to petition for me?
So that's a complicated question again. If the person's under 18, then they would be considered a step parent, and step parents can petition. If the person's over 18, then the step parent wouldn't count as a parent for immigration purposes to be able to file a petition.
Okay, great. And the last question from Francisco Ramirez. You have your hand up, Francisco. Can you open your microphone and do the question?
Hello?
Yes, Francisco.
Yes, I had a question. So my dad is undocumented, and he's been trying to get his citizenship. So he has his work permit, but the lawyers he's been going to lately, they've just given him the runaround. They keep telling him, oh yeah, we'll contact you when we have something ready. But they're telling him that they're gonna have me petition for him. I'm 24 now, which we tried already, and the judge didn't. I guess he didn't accept it. But they're saying that they're gonna try again to have me petition. So I don't know. Can he still get his citizenship? I mean, he has his work permit, but
I have no idea. You're able to file a petition. That's the easy part. But again, your dad getting his residency through that petition, if he's been in immigration proceedings, that could affect it. Also depends on like what category of work permit he has and a bunch of other things. So we'd have to follow up on a lot of other things to figure that one out.
Oh, okay.
And again, that'd be helpful if you did make an appointment with us, if you had like a link to the documents ready, so we could make the most use of a consultation.
Okay, yeah, okay.
Great. Okay, the last one from Jorge Vargas. You have your hand up. Please, Jorge, your question. And then after this, we're going to complete our presentation. A wonderful presentation.
Yes, hello. My question is, I'm a DACA recipient. My question is in regards to if one of my children was to petition for me, will I have to leave the country?
So again, for a child to petition, they need to be 21. And if you have to leave, if they are 21, then you'd be in that immediate relative category. So to not have to leave the US, you'd also have to have that legal entry. So if you travel on advanced parole or otherwise enter the US with like a visa or something, you'd be able to, or if you were protected through 245I. So possibly.
Okay, so what about if I have never applied for that advanced parole? Like, does it count? You can
still apply now. So a lot of times our advice to people is travel on advanced parole, and then we'll work on the petition part. That's a lot of times what we tell people.
Oh, okay. All right, sounds good. Okay, thank you so much.
Julie, there's one more question. You let me know when it's over, but there's one in the text, and it said if they would like to petition for their parents, but do they have to be unmarried to petition for my parents?
No, that's an easy one.
Yes,
okay.
Thank you.
Okay, so let's give it a big applause to Julie. Thank you so much, Julie. Wonderful information. Our students and our community is so happy to have this kind of services, and we're gonna do more. Please follow us. We're gonna do another presentation next month, and that presentation is gonna be about Central American students. Am I correct, Marcela? Do you have the right title? Mm-hmm.
Yeah, how it affects Central American students. Just generally, again, just the website that, or the link that Julie put on the top where it says community college students and faculty and staff. That's, if you're a student, fill that out. I mean, that's how you would book your appointment. There was a lot of questions in the chat. What about my friend who's not a student, and maybe somebody that is not a faculty student? Then you would use the other link, which is www.carecen-la.org. Take a picture. We're going to leave it up for a little bit so that you can take a picture of it or log in. I can't tell you the value of having this service to our students by CARECEN. It's a good $3,000 to $4,000 value. Isn't that right, Julie? Or how much do you think? Something, because they will help you with the paperwork, the fees for the paperwork, that's separate. Sometimes they're able to sponsor somebody or to help, but it's such a valuable service. It's it's helping students or people that would make it difficulty because they're having such trouble earning an income. So please take advantage of it and get yourselves in a better situation. I'm so grateful with Julie and CARECEN, like our whole staff is. So I want to thank you so much, and for you and your staff for being here and for answering some questions. I know some of them are so complicated, and I'm just always like my head's exploding all the time. So thank you so much. Thank you, participants. Be on the lookout. We will be having some more, like Laura said. So we'll be sending those out too, the information. So thank you so much.
Thank you to everybody.
Thank you, everyone.
Thank you. Bye-bye.
Hey, thank you.
Bye-bye. Thank you.
Thank you.
Thank you. Thank you, Maria, for being here. Okay.
Thank you, Maria. We'll see you next time.
Yes.
Thank you.
Thank you, Sandra.
Katia, thank you so much for putting the link up too.
Kelly, you still have the hand up. I know that the lawyer is gone, so I don't know if we can answer your question or your concern. Okay. Okay. Apparently not. Okay.
Kelly.
So thank you, Marcela. Thank you, Katia. It was great. So let's start promoting the next one. Thank you.
Yes. Okay. Thank you guys so much. I'll stop recording now, which I forgot.
Yes.
Stop.
Yes.